over this way.
Can bring the board here.
Wrong direction. Oh, I think I need where you are.
Oh.
Thank you. Yes, there we go. And unfortunately, all of that moving is on the video too. All right. Couple of things. I'm gonna go in a little bit of a different order. We're not gonna have a long class tonight. I'll tell you why. Because my registration sheet shows that there are about 30-something people in the class. And I know we're not all here, and I don't have all the case briefings that I should have. And so what we're gonna do is first I want to talk a bit about advising. I want to go over quiz number 1, just to make sure we're all on the same page. I want to continue just our last bit of chapter 9, which is the products liability portion, so we'll talk about that. Then I want to do the same thing we did with the first quiz. We kind of went over some of the questions in class. I want to go over some of the questions in class with you so you sort of know what those look and feel like. And then I want to talk to you about case briefings number 1, some general comments and feedback. And then give those people who have not gotten in an opportunity to get it in, and an opportunity for you to think about any comments that I'm giving in class and see if you want to go back and rework anything. Okay? Sound like a plan?
That would be nice.
All right. So that's how we'll do it. Oh, so advising. How many of you know that Educational Planning Day is next week, the 22nd?
Yes.
Yes. How many of you know who your advisor is? Raise your hand if you know who your advisor is. Okay. Raise your hand if you've actually met with your advisor. You've actually seen them face to face. Okay. All right. Here's Mike. All right. And raise your hand if this is more than if this is your first or second quarter. Oh yeah. Okay. So, all right. So 2 parts. If you, let me back up. And you're in the paralegal program degree, or excuse me, you're in the program for the degree or the certificate. So everyone, this is not an elective. So everyone raise your hand if this is my degree or my certificate program. I'm not here because this isn't an elective class, but I'm really in another program. So this is your chosen program. Okay, all right. So here's the thing. I'm going to, so you got 2 proposals, and you can get both. If you go to the paralegal program Canvas site and you complete the planning sheet, all right, you complete that planning sheet and you send it to me, automatically I will give you 5 points of extra credit. Let me show you what I'm talking about. And I should have flashed power on that before.
Is that the one where we were invited to join?
You can get the form from there, but and I'll show you what I'm talking about.
Okay.
Is it coming out, guys? Oh yeah.
Yeah.
Okay.
It's just,
All right. Just
I
a
think
little
it's
bit.
too bright.
So, P.S. Planning sheet.
So
All right,
do you
5
need
points.
advising for the Triple LT program?
What now?
Do you need advising for the Triple LT program?
I would strongly advise advising. Alright. So have you now, has everyone received your invitation to the paralegal program site?
Yes.
You have not. And you gave me your name indicating, well, hold on 1 second. So if you have not, pass that attendance sheet back and put a star by your name, and I'm gonna know that means that I need to follow up. Does everyone else have access to this site?
Yes.
All right, so the goal of this site is to be your one-stop shop for information that you need about advising and so forth, okay? So we will send out announcements, but sometimes we auto-delete or the email just gets too crowded, whatever, right? So it's also posted here. So when you go into this site, you use it pretty much the same way that you use it in the course. Primarily, you're gonna find information under announcements and under modules, right? So later on today, there's gonna be a little reminder about there being Educational Planning Day next week. But see, there's these nice little job opportunity things here, right? You wanna kind of look at that information, see what's available out there, okay? Under modules, program requirements and advising. This is where those important documents are going to be, okay? There's a lot of other stuff here too, but for purposes of our conversation about advising, I'm gonna focus this here, okay? So students, officer advising assignments, you can look here, and this gives you an indication of how the advising is presently done, okay? You start off in general advising until you have declared, whatever, right? Determined until you set this as being your area of study, and then you're switched over. If you're A through L last name, you're Jennifer, the rest of you are with me. Doesn't matter, we will see you, we wanna make sure you're being seen, okay? So we're flexible with that. I am not even so concerned if you come see me before you go to general advising, I just want you to be seen. It concerns me that not everybody's hand has been up, that they know who their advisor is, or that they have seen an advisor, okay? All right. Advising graduation and required forms. This is where you're gonna go to get that planning sheet, okay? Every single quarter, the due date for your graduation applications changes. We'll always come back and update this. So for those of you who are, you're gonna be done, you're applying for your degree at the end of this quarter, then Friday, December 12th is the due date for you, okay? Complete the planning sheet. So if you are doing the degree, then you're gonna use Form A. If you're doing the certificate, then you're gonna use Form B. The way that you know the difference in terms of which program you can do is you can only do the certificate if you already have a degree from a college or university, okay? You have to already have some sort of associate's or bachelor's degree or some other type of degree in order to qualify for the certificate. Did I lose anyone? Is everybody okay with this so far? All right. So I'm gonna click on Form A for purposes of the degree. Now, if you click on this, if you're familiar with Canvas so far, this will give you a little preview, but if I just click on this, it'll go ahead and open it up for me, at least it should. All right, so this will take us to a lovely little document here. Why is it so small?
Stay.
Okay. All right. So what you'll see here are all the courses that are required in the program for your paralegal degree. Here are your general education requirements, and then here are your elective courses. Our program's a little bit funky. Most of your 2-year degrees are 90 credits. Ours like 107. You know, we're legal people, so we have to be a little bit extra. But nonetheless, you want to make sure that you meet all these requirements. At the very bottom here, pay particular attention because you only have to complete 3 of the courses for a total of 9 credits. Okay? All right, so this is the planning sheet. You know how to get there now? Raise your hand if you've seen this sheet and you filled this sheet out. Awesome.
I've seen it.
Raise your hand if you've seen this sheet, you've completed it, and it's been approved by an advisor. Okay. It's looking all right. Okay, all right. So if you have this sheet already completed, then hey, you'll get your free 5 points. You with me? Just shoot it to me. If you don't, hey, let's get it done and get your free 5 points. All right?
Do you want us to email it to you?
Okay. Yep, you're gonna email it to me. Okay? Is that all right? Everybody got that?
Can we get an
But-
electronic copy of those that's met with you that have paper form? Sort of having to find a way to scan in the system.
You already have it.
Well-
Yeah, if we've already done it, if we've already done it, it's fine. I'm just happy that we've done it. So you can just email me and say, hey, we did this. You got this already. Okay? Is that all right? Yes.
So it's just gonna have my name and student number on it. I don't have anything to fill out since it's my first quarter.
Yeah, no. Okay, that's the next
I'm
part of this.
confused.
That's the next part of this, okay?
Okay.
So she's saying, oh, I have this, but I don't have any of this filled out. Is this your first class? This is
Yes.
your first quarter?
Yes.
Are you taking any general education requirements at all?
No. This class in CU 105.
Okay. See, that for me is a problem, man, because ordinarily what I would advise is that you be taking some of these classes down here, and then we be filling this in a little bit too, okay? But having said that, the way that you're gonna use this is I'm gonna show you another document, and what you're gonna do is you're gonna project ahead and start to plan out your courses. You with me? That way, when we get to educational planning day on the 22nd, You're gonna bring me in a proposed plan of how you're gonna complete the remaining courses for your program. We're gonna take a look at that. You do that, if you don't have to see me, but if you see, even if you see Jennifer, you see somebody, 10 extra credit points. So you got a total of 15 possible points. If you actually come in and you see somebody on educational planning day, say, hey, here's my plan, this still looks good? Okay, we're good. Oh no, here's my plan, I need some help, look this up, over, 10 points. I know, this seems like bribery. I own that.
I'll take
I
it.
know that.
Hey, I got kids, I know about it, but, if we can get Jennifer to send you an email saying you chatted with her or anything, cause I know somebody like myself, who works full time, it's kinda hard to get here during the daytime, that's why I take night classes, can we still get those?
So here's the thing, here's the criteria, okay? I don't care if you talk with her on the phone, I don't care if you Skype, I don't care if you tweet, I don't care if you Facebook, I don't care if you have to do something. My point is, I want this done. You have to give me some proof, you have to show me, hey, we've done this. Do you follow me? What your process of communication was to get it done, I don't care about it. But I wanna see this document. I want documentary evidence.
You can't just hand you the paperwork.
That's documentary evidence.
Yes, but you said online, but we can still.
Yeah, if you wanna, if you wanna bring it to me, that's fine, I'll take a hard copy. I'll take it hard copy, I'll take it electronically. Okay? I don't know how late.
Sounds like great eggs and ham, I'll eat them.
I'll eat them. That's right. Yes, ma'am.
Should I have been meeting with you or Jennifer already, because, I have the general advisor guy,
Kiko.
Kiko, and he said that I would need to meet with him until, I forget the point, but.
Yeah. But here's the thing, I understand that there's some stuff going on in advising and all that kind of stuff, whatever, right? I don't care about that, okay? If you've met with somebody, great. If you haven't met with someone, what I'm saying is I want to make sure that to the extent that I see you and you're in a class with me, I want to make sure that I've done my, what I call in the legal profession, due diligence, and maximize an opportunity to make sure you have the information you need to make sure you're on the right course for the program. You with me? If, John, you've already met and fell in love with Kiko and y'all worked this out beautiful, just send me what y'all did. You with me? If you have not met and fallen in love with Kiko just yet, because you will, because he's wonderful.
I've done a couple.
Awesome. So then if you guys have done this, wonderful. Shoot me an email, say, hey, here's what our plan was. Make sure you fill it in though, right? Update it, okay? Don't just send me an old, antiquated document. Put in the stuff that you've done since then. Does that make sense? Everybody okay with that? All right, so let me get back to your question. So you said, wait a minute, what am I gonna put on here? Okay, let's talk about what you're gonna put on here. So I'm gonna go back to the paralegal program site. Third, I'm gonna go back to that same top category there. Did I lose anyone? Everybody okay? All right. And I'm gonna click on what says paralegal classes 14-15. Okay. I'm just gonna open this up. And don't worry, I did not have tea and chocolate today. Only a little caffeine. I don't think it's gonna have the same effect, so.
I kind of like the tea and chocolate.
Yeah, we like to on the team.
I was gonna say, I thought it was quite fun.
Yeah.
I have to figure out how to delete those videos and word. Okay, so now, have you seen this before?
Yes.
Awesome. All right, so this is a projection of the courses that are gonna be offered. We'll make some tweaks, whatever, but for the most part, you should be able to look at this and have an idea of, okay, here's what they're gonna be offering during winter quarter, here's what they are going to be offering during spring quarter, okay? Now, this is not gonna tell you the times, because we're not that, we're not there yet, but at least it's gonna tell you what's offered, okay? You have to work out the time thing later on. So, back to your question. What you're gonna do is, we're gonna come back to your sheet, and we're gonna say, intro to civil law, pending. What's this quarter? Fall 2014. Oops. Which other class you're taking?
CU 105.
Do you mind? Are you okay
No,
with it?
it's the first one.
Okay.
CU 105.
So here we go. Pending. Fall 2014. All right? Then we say, okay, cool. So I got these classes. I'm jamming. Let me see what I can take next quarter. So we're gonna come back and we're gonna look at this form here. we're gonna say 1 1/4. Okay, now what should I take?
Well, I
And that's a
looked at it.
conversation that we're gonna have because we kind of want to go in order, right?
Right.
So let's see. We have 106, writing basics, fundamentals, legal writing. So that's kind of the general idea of the courses we want to take, right? Okay. So you come back over here. Now we have an idea of what we want to take. Let's see. So let's see. So 1 1/4. We have legal writing 1. It's gonna be in the evening time. Your evening this quarter. Can you do evening next quarter? Yeah, you got 1 class. So we're gonna put that in. Anticipated, as opposed to pending. Anticipated. Winter 2015,
Okay.
and we're gonna start to plug that in.
Okay.
Okay with that?
Yep.
All right. So you do this. Actually, to make this cleaner, people, I'm sorry, you're not gonna email it. What I'm gonna do is I'm gonna create a category on our course site that says extra credit. You can drop off. And then it'll say advising planning sheet. You with me? And you'll just drop it off in that box there. And then that way I can just plug in your points right there. All right? Educational planning day. You come in,
What are the hours for that? Do
you
know?
talk to people, you do something. So educational planning day, so each advisor is gonna have different hours, okay? I can tell you, what day is the 22nd? Wednesday, so I can tell you now, my hours for educational planning, I mean 9 to 4 p.m.
Because open.
And then you're gonna call me and schedule something if you need to be later. Cause usually I will be later and no one will come see me. I have all these toys for the kids, in case you want to bring the kids, all these damn treats that I can't have. Sorry. So, now it's 9 to 4, but if you need to be later, I can be later, but we're gonna set up an appointment.
Do we only need to schedule the appointment if we need to be later, or do we just come in?
That's right.
Okay.
So you can just come in. If you actually schedule appointment though, I'll block that time out, and then that way it'll be uninterrupted period. Okay. But otherwise, these are going to be the times I'm going to be here. Okay. Everybody okay with that?
Yes.
All right. Cool. All right.
Just by chance, do you know if that's Jennifer's?
I do not.
Okay.
So make sure you make direct contact and confirm.
No.
I'm pretty certain
It's
she's
in
going to
your
send you out an
syllabus.
email. Well, her office hours, but her time frame for educational planning day might be different because that's a day that's just purely dedicated to advising.
Gotcha.
So just follow up with her, and I'm pretty sure she's gonna send you an email too. But don't wait. Email too. All right, so that's your advising. All righty. Let's look at quiz number 1. Now at this point, everyone's taking it, right? If not, it's too late. Is that right? What was up here? Lindsay? No, not yet. Okay. Are we okay with, do you want to turn like a couple of lights off or not too many? Maybe just something. Is that okay? What do you think? Good? Good. Alright. Okay, let's make a beer too. Alright. You okay? Alright, a party who brings a civil cause of action for fraud must prove the allegations by a preponderance of the evidence.
False.
false. Why is it false, John?
Because I selected true and I got that one wrong. So.
Okay. All right. Ellie?
It falls under that higher, when we did that number line.
Yes, ma'am.
But I don't remember the words.
Okay. Does anyone remember the phrase that higher burden of proof?
Clear code.
Yes. Clear, cogent, and convincing, or sometimes clear and convincing. All right. In both criminal and civil cases, a defendant has a constitutional right not to testify, and there can be no negative inferences drawn from such. Is that true or false?
False.
False. Where do you have the right not to testify?
Criminal.
Criminal cases. Very good. Substantive law refers to the process by which a party seeks to enforce their rights.
False.
False. Substantive law refers to what?
I think I got that one wrong.
That's right, defining the rights. What are my rights? You with me? What refers to the process by which you enforce the rights? Procedural. Very good. The Washington State Constitution provides the same degree of rights and protections as the United States Federal Constitution. It's false. Remember I told you about the love letters? And then I gave you the example of the garbage, right? So it is incorrect to say that they provide the same degree of rights. Washington loves you more, gives you greater protections. Yes.
And you did say that, I guess the way I was reading the question was that our state constitution basically doesn't violate any of these. These are carried over and we have greater, but
Not less.
it's not.
On its face, when you read this question, this is incorrect. Washington State Constitution does not provide the same degree of rights. And if I'm arguing in court, I'm going to say exactly that. Your Honor, counsel is incorrect. That is an inaccurate statement of the degree of protection we are afforded under our Washington State Constitution. Case law is emphatically clear. We are afforded greater protections.
Very good.
All right. Case briefing and analysis. By what standard does the court indicate it reviews a trial court's decision to grant a CR 12B6 motion to dismiss? How'd you know?
I don't know, Russia.
How'd you know? 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 Where did I get this question from? Where'd you look? Did you just guess?
Probably.
Let's see. Preponderantly. Okay, fine. Yeah, that was kind of wacky. It wouldn't be preponderance of the evidence. But you could have selected abuse of discretion because that's also a standard. So how did you guess between the two? Where did we get this from? Remember your Rothwell case? Remember she brought a motion, a motion to dismiss? Remember? They talked about the standard of review in that case? Yes, yes, yes. Remember the case of the suicide and all that? And then we talked about different examples of those things. Yes.
So I still don't get how you decided on that one. I mean, does that have to do with what CR it was, or?
No. And no, so you didn't have to know the 12, whatever. You didn't have to know this. As long as you knew the motion to dismiss, and you look at this, the materials. So in that Rothwell case that we spent all that time on, right? In probably the first 2 pages of the court's analysis, it talked about the standard of review for the motion to dismiss.
But sometimes they don't ever use of discretion?
They do, but it varies. It depends upon what the issue is that's being appealed. So each issue is going to have a type of standard of review that is applied. So for this particular type of issue, the standard is de novo. And another type of issue, the standard might be abuse of discretion. We talked about the example of the trial court denying a pro se litigant's request for a continuance after he had a whole bunch of different attorneys and so forth. And the court said, no, we're not going to give you a continuance. And he appealed. The standard of review for that was abuse of discretion. The standard of review in this instance is de novo. Do you guys have that Rothwell case on you by any chance?
No.
Y'all just toss that, like, oh, we don't do
Does the CR mean court of review, is that?
So court rule. So go back to the very beginning and then we, RCW, what? What's the RCW gonna be? Revised Code of Washington, those are statutes, and if we have this right here, WAC, this is gonna be what? Very good, Washington Administrative Code. CR, Civil Rules. C, small r, big R, what? Criminal rules. Okay? And then we could go to LJ or whatever. Okay. Never mind, I'll stop there. You're killing me. Okay. All right, next question. Which of the following statements are incorrect as it relates to the U.S. Supreme Court? Okay, so one of these statements, incorrect. The Supreme Court has vast general jurisdiction. False.
Limited jurisdiction.
Yeah, limited. Remember, you're gonna get there by appeal. They're not gonna take everything. The Supreme Court, oh, you guys, I have to tell you this. So, all right, no. I went to, what was it called? Where did I go? Oh, it was called the Washington Women Lawyers. It was their annual banquet. And instead of having, so it's a dinner, nice fancy dinner, not enough food, but whatever. But it was really nice, and they were giving out awards, and instead of having a keynote speaker, they had a keynote discussion. And so they had judges, female judges from Eastern and Western U.S. District Court, Federal Court, okay? Judge Peterson and Judge Peckman. And what they did is they had a facilitator who asked questions of each of them, and they just sort of had this really nice conversation. And Judge Peckman was such an incredible person. It was so funny. You would never expect, she cursed. She did. And I think I can say it on the tape because a lot of people were there and they heard her curse. Anyway, it was really interesting. And they got to a point where they were asking her, well, what kind of advice would you give people, you know? And one of the things that she said that I thought was she said a lot of things, but one of the things that was really salient and I just thought was incredibly memorable, she said, do the best that you can do. Do your very best. And then once you've done your best, be satisfied. You like that? Because don't you obsess after you do your best? And then you're like, oh my God, I could have done this, I could have done that, whatever. Do your best and be satisfied. You with me? And then if you feel like you need help, come back and get that. All right, why I had that moment to say that, I don't know. But I wanted to share that with you. Okay, U.S. Supreme Court vast general jurisdiction, that's false. The U.S. Supreme Court allows two methods of obtaining review, by right and by certiorari. Is that right?
Yes.
That's correct. Which is the more common method? Certiorari. Very good.
How do you say that again?
Certiorari.
Certiorari.
The appeal by petition or writ is the more common method of obtaining Supreme Court review. That's right. That's what we just talked about. Okay? So the first one is the one that was incorrect. Are we okay with that? All right. Civil procedure. Which of the following statements is correct about Pierce County Superior Courts? It is a court of general jurisdiction. Is that right? Is it?
Yes.
It can only hear felony cases. It is a court of limited jurisdiction. It cannot hear federal claims. Huh? Huh?
False.
False? It can hear only matters in which the county is a party. So which statement is true? The first one. It's a court of general jurisdiction. Are we okay with that idea? Yes. Excuse me. The process of incorporating public law into the existing legal statutory code is known as? Yep. Codification. Are you guys okay with that? Do you not want to go back and look at the other ones?
Oh, no, I was just.
The way you say the word.
Pronunciation of
codification, potato, potato.
Got it?
Alright.
Next.
Just sit there and touch it.
That's right, we're trying to run a tight ship now. Now stay focused. The court.
Not heard.
Speaking of which, you're still gonna talk about that case?
No, we gotta stay focused. Okay, alright. The courts in common, Jenna, you're supposed to help me stay focused. You know how I can get it.
All of the above.
Okay. The courts in common law systems have developed a body of law that serves as precedent for determination of later controversies. This is called judicial law, common law, case law, all of the above.
All of the above.
Alright. We should make a Jeopardy game, guys. Don't you think?
Yes.
You guys don't watch Jeopardy?
Yeah.
Did I just reveal my nerdiness?
Yeah.
No?
Gotta get out of here.
Alright. In EEOC versus Alamo, the court denied the plaintiff's motion for partial summary judgment, concluding that Alamo, Alamo, sorry, typo, had presented genuine issues of material fact concerning both the religious discrimination and reasonable accommodations claim.
That was false.
Very good. How'd you know this?
We read it.
Good to read the case. Alright. All but which of the following statements are correct as relates to the issues, analysis, and determination in Iowa v. Lexington. Did you guys read the case?
Yes.
Fascinating case, huh?
Interesting.
You guys find it interesting?
Yep.
All right. The defendant appealed her convictions and sentence contending insufficiency of the evidence supporting the element of control or custody. Was that true?
Yes.
The defendant appealed her convictions and sentence contending insufficiency of the evidence supporting the element of knowingly acting in a manner to create risk. Did she? You guys remember?
Yes.
The defendant appealed her convictions and sentence contending insufficiency of the evidence supporting the element of willfully depriving the victim of health care or supervision. When reviewing a challenge for sufficiency of the evidence, the court reviews the evidence in the light most favorable to the defendant. That's right. False. Very good. Everybody okay with that?
Mm-hmm.
Wasn't that a crazy case? Crazy. Which of the following statements are true as relates to the publication of federal legislation? Federal laws are officially published in the United States Code. All laws are divided by titles. Each law within a title is assigned a section number, and that law is later, and if that law is later amended, the amendment is assigned the same number. If an additional law is passed on a general subject, and that particular law is a new subject, it will be given a new section number.
Yes.
All right, good. It's only 15 questions, but it seems like a lot of questions. A decision, it wasn't timed, was it?
No.
Okay, you guys like it not being timed, right?
Yeah.
Right.
Okay. A decision of the Washington State Supreme Court would always be binding on a federal district court in Washington? A federal district court? State court? A state court in Washington? State trial court?
Yeah.
U.S. Court of Appeals, Ninth Circuit? State trial court in Oregon? No? What? Okay, very good. So state trial court in Washington. All but which of the following statements are true as it relates to federal jurisdiction? Federal courts have specified and limited jurisdiction. Is that true? Yes. A party may file an action in federal court if there is a federal question or diversity jurisdiction. Yes. Where parties are present in federal court on the basis of diversity jurisdiction, the federal civil rules apply. Yes? Yes. Huh? Okay. Let's go to the next one and then we'll come back up, okay?
No. What I'm
No?
saying is I misread the statement, so I got it
Okay.
wrong.
Federal courts have exclusive jurisdiction of those cases involving the federal constitution. So which one is, so the one before that, okay? All right. One last question. So this one is the one that's incorrect. You guys good? Which of the following statements are true? So which one is the one that's not true? This one right here. Okay? Federal courts have specified limit jurisdiction, that's true. Federal question diversity, that's true. Federal civil rules apply, that's true. This one, not true, because who else can hear a question regarding the federal constitution?
Supreme Court.
State court. We okay with that? Excuse me.
You need chocolate milk tea then?
Okay, this is the wrong question. Alright, in affirming the district court's determination of custody/visitation dispute between the natural parent and the third party, the court in the Edwards case evaluated whether there was enough evidence to demonstrate a sufficient period of time to develop a psychological parent relationship. The reviewing court cited to all but which of the following factors as support for the district court's determination that such a relationship had been developed. So they looked at all of these factors except for one.
That's it.
The district court found that the child had only minimum contact with their biological father. Did they find that?
That's true.
The district court found that the third party had loved and cared for the child in the same manner he had for the twins the parties had together.
Yes.
The district court specifically found and labeled the third party as a psychological parent.
No.
That was the basis of the appeal. There is no evidence presented to the district court to suggest that the child's natural father had any intentions of playing the role of the third party.
Yeah.
The court considered all the factors. No. So it was the psychological parent. And how would you know that?
Read it.
Because you had to read
Read
kids. All right. Everybody okay with that?
Yes.
Yes. Are you okay if we keep going and finish up chapter 9? All right. Let me switch to that. So there's not too much here. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. Okay. That's not a lot. That's fun. All right. So, I'm not going to review just now what we spoke about last week because we're gonna do that in the next thing, okay? So I'm just gonna pick up a products liability. Are we okay with that idea?
Mhm.
All right, so what you're told, instructing in your text is it's not a specific body of tort law, but basically it just describes an area where we have something that's based upon one of these couple of theories. It's not very complicated at all, okay? Bottom line, we got an action that relates to some sort of faulty product. So either the product itself or the design, and we'll talk about those distinctions in the next couple of slides. All right, so in our days of common law, really long time ago when we were first doing this, okay. In order for the plaintiff to recover from an injury from the product, they had to show privity. Remember when we first talked about like the development of tort law, development of law? I told you how initially you had to show some sort of contractual relationship, but then that was too limiting, right? Because whatever the thing is that produced harm could not only go from you, but then you probably give it to your mother give it to so-and-so or whatever, right? And if the product is faulty, then the fact that it passed through the hands may or may not be relevant to whether or not the person who made the product should be liable, okay? So we have the same idea here. So you had to initially show privity, contractual relationship, and either fault or negligence or warranty, usually an express warranty, meaning there was something that was expressly guaranteed explicitly about that product, okay? Then we have this sort of movement, and this is a quote from a very famous case. Justice Cardozo talks about this idea of foreseeability creates a duty, not privity. So it's not the relationship, but it's whether or not it's foreseeable that that product could pass to someone else and potentially be injured or harmed. Does that make sense? So you see how that's kind of expanding the scope of liability. All right. That's our basic background. That's our background. So then we have two different ideas or general concepts here under product liability. Manufacturing defect. So when the product came off the assembly line, it did not look like it was supposed to look. There was something faulty about it, period. Okay? You bought the product and it's not consistent with what that product should be. Then you have the idea of the design defect. Design defect says, well, the product came off the shelf exactly like it was supposed to come, right? It's not that somehow it got messed up on the assembly line. It was made in the way that it was supposed to be made. However, the way that it's made is just wrong. The whole product line itself is badly, poorly designed. Does that make sense?
So does that then become strict liability?
We're not gonna go there just yet.
Okay.
Right. So, all right. This is a toaster. Here's my bread. That looks like a toaster, right? Mm-hmm. That looks like a toaster. A Pop-Tart? Okay, yeah, do people put, my kids don't eat Pop-Tarts, but you put Pop-Tart to the toaster, don't you? Okay. No, my kids are picky. They have to have pancakes and waffles and sliced fruit and stuff. They can have parts of
stuff.
Okay, sorry.
They don't want sugar.
Little. You just won't take my pearls stuff out of you. All right, so, but I would look, they're only like 99 cents a box. I see them all the time. Like, hey, would you guys like some Pop-Tarts? No, that's gross. Okay, whatever. All right, so this is a Pop-Tart. All right, this is our toaster, okay? All right. Our toaster is supposed, this is the way we get it from the store, right? It has a little fake Pop-Tart thing, okay? So when we buy it, it looks exactly how it's supposed to look, okay? But when we get home, what we realize is that, oh, it doesn't work. There's some fire coming out of it, right? Okay? But it's not the entire product line. It just so happens that, maybe this one got bounced around and a piece came apart or whatever, right? So we could just take this back and say, hey, I don't want this one, I need a different one, right? Because I think somebody maybe this one, kind of got broken and whatever, right? So we're not saying that the whole way that the product itself is. So under this one, we're talking about a manufacturing defect, just this particular toaster, okay? Is everybody okay with that? All right. Now, underneath this one, we get it home, it's exactly how it's supposed to be, okay? It wasn't bumbled around or anything like that. But every single one of these toasters, or nearly every single one that you buy all across the country, people saying, oh no, when I put my Pop-Tart in there, I get an explosion. You with me?
Like a product recall.
So there's something faulty in the design itself that went wrong. And that's exactly where we get those product recalls from. We gotta recall the whole product. This series or line of toasters, defunct, something's wrong with it, bring it back. Okay. All right, so some common causes of action. We got breach of express warranty. How many of you actually read the warranties that come with all the products and things that you buy? No, you don't. You read every word for word, page for page, all that stuff, you little bitch. I'm just kidding.
It was a $2,000 guitar, so.
All right, okay. This is exactly why you should, if I pay $2,000, I'm gonna read every word too, right? Okay. Let's see, and you have to fill out the little cards. You fill out the little cards. You can do it online now. Make sure you do that, because that's actually what triggers your warranty and your entitlement to get your refund and all that kind of stuff. Okay. All right, so we have a express warranty. Guarantee by words or pictures that the manufacturer or retailer that the product will have certain qualities. So his warranty that he read about his guitar, all of that, it was express language, worrying about here's what this product is going to do, here's how this product should work, here's how long we guarantee this product to operate for, so forth. As long as you use it in the manner consistent with what it's purported to be used for, right? Everybody okay with that idea? Breach of implied warranty and fitness for a particular purpose. Goods are impliedly warranted to be reasonably suited for ordinary uses for which goods of that type are sold. So basically what this means is that irrespective of any warranty, right? If I put this on the market, this toaster, I'm saying, hey, this is a toaster. You expect a toaster to be able to toast things like bread and Pop-Tarts. it's gonna work for that purpose. With me? Now, let's say I wanted to make, what's something that you would not make in a toaster?
Grilled cheese.
Grilled cheese, right? Okay?
Inside.
So you are violating the warranty. So you cannot call them about your grilled cheese because they're not telling you this product is for grilled cheese. You with me? Does that make sense? You okay with that? All right. So they're saying it's for the purpose that we say it is. So there's an implied warranty that, hey, it's gonna suit this purpose. Okay? Now if you go outside the scope of that, then you go outside the scope of what you're covered for in the warranty. Whether it's expressed or implied. All right. Common causes of action. So again, we can have this thing, we can have the idea of negligence. We can also have deceit, but probably more so negligence. And then we have the idea of strict liability. Okay? Strict liability. So your I think title, okay. I think there's a link to that. There should be a link to the RCW when you go home and read this. A product manufacturer is subject to strict liability. Hey, does that mean you go home and you read all my PowerPoints, sir? Do you read all my PowerPoints?
Not all of it, but
We have them. But you read the warranty? If I told you my PowerPoints were worth $2,000, would you? I'm just messing with you. All right.
$20,000 for the class.
Well, there you go. So you already read my PowerPoint. Okay, all right. A product manufacturer is subject to strict liability to a claimant if the claimant's harm was proximately caused. We have that language again, right? You have to show that what your harm has a relationship to the product defect. Proximately caused by the fact that the product was not reasonably safe in construction, or not reasonably safe because it did not conform to the manufacturer's express warranty or to the implied warranties. Okay? So there's our look at that. Interesting case? Not found? Okay. That's all right. I'll put it up there later. I don't remember the facts of it off the top of my head. You guys, this PowerPoint slide was long.
Mm-hmm. 84 slides.
How many?
84.
Wow.
You got on
Did I put the page number in there?
Yes.
Maybe I shouldn't do that so you're kind of misled about how long it is. Okay. All right, so defenses. So our defense is the product liability. Same thing as in other areas of negligence. Maybe we can say that the person was contributory negligent. You should not have been trying to make your cheese sandwich. Right.
Sometimes when you're hurrying,
Okay.
I knew it.
All right. Extreme misuse. Maybe the product was not used in the manner in which it was intended for, or was abused or inappropriately used. So, ladies, do you use a curling iron?
Yes.
Or a flat comb?
Yes.
Or anything hot to put rollers in?
All of the above.
All of the above? All right, so have you looked at the things and they say, like, do not touch or do not use around water?
Yeah.
Or, right, all those things. Do you know why?
Yes.
Because
Because
people say
somebody
other
did it.
things.
Because somebody did it.
Right, and then they
That's what all
swear.
green labels are for.
Right?
They're ridiculous.
Somebody
All right.
on those questions,
Um,
don't we all curl our hair standing over the sink?
With
Not in the bathtub, though.
With some people, right. So you have all these kind of warnings as a result of some sort of litigation previously, where people were using the product inappropriately. So here was a defense. Well, actually, they're not using the product for the purpose intended. Let's see. What was there? The shoot. Aluminum foil. Aluminum foil. You can someone was using you know what I mean to say, aluminum foil and bakers.
Yeah.
Right. Kitchen. Okay. So they put it in the
Microwave.
the dryer.
The
It's
dryer.
in the dryer. You ball it up. You put it in the dryer, and it's supposed to be something about static.
What?
Okay. But they also had a faulty dryer, and so
Caught on fire.
right. So some explosion stuff happened, and so they wanted to sue about aluminum. No. You can't do that. So these are just examples of how you have to make sure that you're complying, or if you're not, those same ideas of contributory negligence and so forth come into play in terms of defenses.
How are they supposed to know they had a faulty dryer though?
Well, why would you put foil in there?
I know.
Dryer?
Well,
I'm just saying,
well,
though, like-
I mean, if it's kind of smoking.
Well, yeah, at that point.
I mean, and I think that's
But
what's
before that.
I don't know. I mean,
Just put a tennis ball in there.
Fabric softener.
Tennis ball works.
Fabric softener. Or hang dry, I mean. Alright. The next idea, concept is that of statute of limitations. Okay, we have two things here. So the statute of limitations, I told you before, is referred to in civil law as limitation of actions. Okay, part of your ATC assignment is to look at various statute of limitations. Okay, all right. So this is a time frame. Typically, the time frame starts to run at the time the plaintiff knows or should have known. Knows or should have known. The should have known. Sometimes you'll hear that referred to as discovery. The point in time they discover. Okay. Statute of repose is a little bit different than the statute of limitations. All right, and here's how it's different. And sometimes this gets a little confusing. So let's say my just for clarification, this is just kind of where we are in the material, but the statute of limitation applies to your negligence, your intentional torts, and all of this stuff. Okay, it doesn't just apply to products liability. So we're just kind of moving on to different themes. Okay. So let's say let's use Tickle. All right. Maybe that she's gonna have a claim of defamation. Okay. What's the statute of limitations? 3 years. All right. So this is 3 years from, let's say it happened on 10/10/2010. 10? All right. So we got 10/10/2000 and her thing is up. Anything? Statute of limitations. So it starts, it runs from the date of the incident itself, date of incident or injury. Okay? Why do you think there's this language about when they should have known?
Because what if she didn't know the day that he said it? I mean, like if he said it on 10/10, but she didn't know about it until 10/15. I don't.
She's still a year late.
Yeah. Anybody else?
No, she don't be happy.
You hear about, so think about this in a different context, not necessarily with a defamation. Think about it in terms of maybe the idea of someone
What about like the,
like a claim about some sort of disease or condition as a result of exposure or something, right? I may not know the exact date of impact, right? But it's the date from which I discover it, the date at which I become diagnosed with it or something. Yes.
what about like on, just so I make sure I'm clear on this, these class action suits that the different cervical bladder slings and all that other kind of stuff that they do, you wouldn't necessarily know you had it until maybe 10 years after you had it done, and then you started
10 years
having
ago,
problems?
Yeah, 10 years is a long, long time, but that would be an example of the idea of discovery, the date at which you discovered, the doctor says this is tied to this.
So you'd only have so much time from that
Exactly.
date, not from the start of when you got it.
Exactly.
Is there
Okay.
such a thing as criminal proceedings?
As a statute of limitations? Absolutely.
I know statute of limitations, but the statute of limitations.
No. So remember, in terms of criminal proceedings, the idea is the last date by which we can charge your case, or the time frame by which we have to sort of file your case. The only thing that there is not a statute of limitations on is what? Murder.
I was just wondering, because like if a child was molested and then they got older and found out.
So it's still the statute, so it's still gonna be under statute of limitations, and then it just kind of depends upon the age and so forth and the time frame. And so we can take a look, well, I guess I could show you that. What I'd rather do is I just post it on Canvas, because it's a little bit beyond the scope. But yes, yeah. But it's not statute of repose, though. All right. Statute of repose places absolute limit from the time of manufacturer in which action can be brought. So basically, this is sort of like placing a time frame in terms of when the product was actually placed on the market. Do you have babies?
Yeah.
You got babies?
Yeah.
You got car seats? You ever look at the expiration date of your car seat?
Never did until now, like the last year.
Ah.
I never thought that it would be the plastic decomposes, so you can't use it after 5
Isn't that
years.
interesting?
Or I had one from 2003, and I had no idea.
So that expiration date, so that's gonna be relevant in terms of, okay, when did they place them on the market and so forth. If there's an issue with that, we'll look at that in terms of discovering if you were contributory negligent to the extent that you were aware of the expiration date and used beyond that and so forth. Alright. Lastly, is this the last section? Yes. Alright, the last section covered in your torts chapter 9, is employment. Alright? Employment and torts. We kind of got a little bit into this with our Professor Tickle pattern. So you're introduced to a couple of concepts here. So the first one is the idea of the doctrine of respondent superior. You've heard of this doctrine before? Okay. All right, so under this doctrine, a superior is going to be liable for the injuries caused by his employee. We're kind of agents of the employer, right? So if you cause injury to someone, then I'm going to be liable because the idea is that, well, I'm supervising you, I should be aware, you know, properly train you and so forth. Do we have exceptions? Yes, we do. So this typically does not apply to intentional torts committed by the employee unless it was done within the scope of the employee's duties, because then that would bring it back to you being under my control and supervision.
So like Mrs. Tickle being on a trip for the school to
That's
the
right.
meeting, she was still under her employer's control because she was going to
Interesting.
function, right?
What do you think
She
about
was
that?
out of the scope of what she was supposed to be doing.
That's right. That's right. If you're representing TCC, what are you gonna say, Jenna? If you're okay, say again. If you're representing TCC, what are you gonna say? If they say she's under the scope of them because she was going to, you know,
Meeting for the school.
a meeting for the school.
But she went to go visit her
You
friend.
can always task anybody. Anybody, what are you gonna say if you represent
You were just saying
TCC?
she was in
She
their
was still
vehicle.
driving the company car,
Yeah, she was driving the
therefore
company
still an
car.
extension of her employment.
So if you're TCC,
No.
Oh,
you like hell no, She may have been a mistake, right? So what are you gonna argue on TCC? That's right. You're gonna say that this was not within the scope of her duties. This is not like Rockwell where we actually directing and instructing her to do X, Y, Z. We told her to do A. That heifer was doing B. Yeah, with me? Make sense? Right, exactly, right? So
I was curious because
that's the Georgia in me, sorry. But you take my meaning, right? Okay, so frolic and detour. An employee's injuries and or actions may not be covered if it's shown that the incident happened while the employee was acting outside the scope. So we're going to say that Professor Tickle was outside the scope. Now, it doesn't mean that she's not entitled to recovery from the other driver if we can show that he is liable, right? But in the context of whether or not this might be something that she's going to be covered by, for example, under the Industrial Insurance Act, where you have to be in the scope of employment, we might say, no, we're not liable. You better go sue that other driver because you're not going to get anything here because you were not in the scope of your duties. You were under what we call a frolic and detour. You had deviated from the course of your required activities. Okay? With both the visit to the professor and the drinking. Right? Really, do we want to be TCC? Oh, yes, we authorized her to go and, you know, have a little wine and... All right. So there are various federal and state agencies that set and enforce safety standards for the workplace environment. They heard OSHA.
Yeah.
Any other? What are some other agencies that might set some safety?
What did L&I with labor and industries?
Yep, that's right. Labor and industries. So these are all other types of, just some examples of where you're going to have some standards that relate to workplace safety and requirements. Workers' compensation, we spoke a lot about that in the context of the Rockwell case, statutes that provided basis of compensation to employees injured on the job. Remember, we like this system because it's a no-fault system. There's no fault. You're injured on the job. You're doing it in the course and scope of employment. Then the idea is that you're going to be entitled to medical benefits, time loss if required, even vocational retraining. No fault system, okay? The employers play into this, this fund. All right, and again, this operates as a sole basis, or excuse me, your sole remedy, right? Unless you can prove for some reason that you go out, you're entitled to go beyond the scope of that. Some of the other benefits, well, you can see how we decrease the amount of litigation, right? Encourage safer working environments because now you want employers to sort of be more prudent and cautious in terms of the environments because you know that they're going to be on the hook. The more accidents that happen on their job, the higher their premium is. So it's kind of like in auto insurance, right? You evaluate the risk of that category or that job classification. And that's going to determine, depending upon what category they fall in, that's going to dictate how much the premium is. Okay, the more injuries you have, the higher your insurance is going to be. Strict consequences for claim suppression. Do you know what claim suppression is? Believe it or not, sometimes you have employers who are what we call bad actors, and they attempt to suppress an employee's claims. And so, under the statutes, at least the ones that we have in Washington State, there are very strict consequences for that. All right, discrimination laws. The discrimination laws also fall under types of torts, okay? Protection against discrimination based upon race, gender, sexuality, age, religion. Those are some examples of classifications or categories. Let's see, employer has a duty to monitor conduct of his employees, so this goes back to that idea of respondent superior, okay? Laws aimed at facilitating fair and appropriate workplace environment. Arguably, if you have these sort of issues, then those would be things that would detract away from a fair and appropriate work environment.
So can I go back just to the employers that are bad actors, when they're suppressing claims, do they prevent their employees from filing a claim?
Yeah.
Or
Sometimes they do. So sometimes they will try to discourage employees from filing claims. Sometimes they will sort of passively suppress claims by not providing the proper paperwork or completing forms. Yeah. And in other instances, sometimes what I've seen is they will threaten the person with the loss of their job. If they come. Okay. Alrighty. It's terrible stuff. But it does happen. Alright, let's see here. Discrimination law. Okay, so in the context of your role as paralegals, your firms and agencies, you're gonna have a lot of policies. You're going to have policies that relate to discrimination, policies that relate to sexual harassment. You're going to have policies that relate to what we call netiquette, internet etiquette and engagement. You're going to have policies that relate to your use of electronic resources beyond just the internet, maybe even playing music on your computer and things like that or whatever. So you just want to kind of be mindful of these things. Additionally, where you are responsible or tasked with using employer resources like a vehicle or like cell phones, again, you want to be very careful about the manner in which you use those things, because if there is something that happens and you fall into these categories of where you might be injured or looking at some sort of harm that's come by way to you, all of these things might implicate whether or not you were in the course and scope of your job. Okay? So in addition to whether or not you might be covered under various protections, it also might compromise whether or not you continue to be an employee there. Okay? All right. That is our chapter 9. That's tort. Fun stuff? Yes, yes, yes. All right, let's look at the quiz for chapter 2. Are you guys okay? How you feel? You all right? Can we keep going? All right. Let's look at the quiz for chapter 2. We're going to use the quiz 2 ways. One, to prepare for the quiz, and 2, as a review in terms of our material, because it's a lot of material. All right. Assignment. Okay. All right, got it. Sorry. Good on.
Now, what part of Georgia are you from?
Macon.
Oh, beautiful.
Alright. Okay, so you guys, I have to fix this so that I take it off the timer. Alright. So did you read the O'Neill case?
Yes.
Right? In O'Neill v. St. John Hospital, the court indicated that it is generally accepted that in, alright. It generally accepted that in adopting the 1993 amendment to the statute governing the burden of proof in negligence/malpractice cases, the legislator intended to limit malpractice claims to the pre-Falcon state of the law. If it was more probable than not that the plaintiff would have died even with the best of treatment, a claim for medical malpractice is precluded. Yes?
Is there something we should have already done?
Is what? If it's quiz?
No.
No, we're just looking at,
You're not gonna
Simple.
answer them? I
we're
thought you
gonna
were-
answer them right now. We're gonna.
That's not the actual quiz.
Yes, it is.
Oh.
Yes, so guys, do you guys remember what we, how, did we do this with the
No.
last quiz?
No.
Oh, really? Oh, so do you wanna do this?
Yes.
I was like,
Okay, well
I'm
then,
confused.
so are you okay?
Okay.
You alright?
Great. I'm just sad and confused, but I'm fine now.
Okay, so here's the thing, alright? Here's the thing, alright? So, I apologize if I didn't do it with the first quiz, but I think that it was pretty, pretty straightforward questions in terms of what we have done. I wanted to kind of do it with quiz number two in particular though, because number 2 is like, chapter 9 is really massive, a lot of information. So I just thought I'd just make sure that we kind of understand the material, plus, we only talked about it once, that's really on Mondays, right? And then you kind of leave, you do your discussion post. So that's the only reason why I wanted to come back to it. I apologize if that's creating any confusion. So I just want to give you a sampling of the questions, go through, make sure we're understanding it. Okay, so that's how I was using it, in terms of reviewing, practicing for the quiz, but also reviewing the material. Okay. We okay now?
Yes.
All right, I'm sorry.
I was,
Okay?
I was confused too.
I think she thought she was supposed to have done it already.
No,
I
no, no.
thought I would have failed it and looked bad, but it
No. So when is this, so this is not even published just yet, and it's not due until,
Saturday.
yeah,
Saturday.
so I'm gonna release it now. Or later if I change the, you guys okay? Okay, so have you read the case, have you read the case? Alright, so what do you think about the answer here?
True.
Is it true? You know what, John, you cannot answer, you just be guessing.
I'm not guessing, no.
Is it true?
I think so.
No.
It's not true?
Don't answer.
She's just cut you off now.
Alright, is it true? We don't know, well, let's.
I'm gonna say
No, you're guessing too. Are you guessing?
No, I read it.
Okay, you read it.
I did my case on it.
Brief on it.
Alright, so
Oh, right, okay, very good. What'd you think about that case?
I thought it was very well done, and, I mean, it gets into the statistical and, I think it was very clear that this man suffered a stroke because he was not administered treatment for sickle cell anemia, and had it been done in a timely manner, his risk of having that debilitating stroke would have been reduced by 50%. And when they first went through in the lower court, they did it by simple math, and that's not the way to look at it. Even when you look at clinical trials and stuff, you have to have a p-value of 0.05, and even by using some of the algorithms used there, the higher court was able to show that it actually was, in one of the cases, a 300% difference towards, for the plaintiff.
So what did the court ultimately rule?
Ultimately ruled that if it's more probable than not that he would have not suffered, it was more probable than not that had he been given correct treatment, he would not have had a stroke.
So this is saying that they're looking at it and suggest that the legislator intended to limit malpractice claims to the pre-Falcon state of the law. The pre-Falcon state of the law says that if it was more probable than not that the plaintiff would have died, even with the best treatment, then the medical malpractice is precluded. So is that what the court said? They were gonna go back to the pre-Falcon state? Yes? Okay, take it, all right. So sampling of your questions. Contributory negligence is a defense to strict liability? Contributory negligence is a defense to strict liability.
No.
No.
Bodily contact that is harmful or offensive can give rise to the tort of
Battery.
In most states, the possessor of land. Huh? I am Alex Trebek. Y'all have to let me read the question.
She just wanted to know if the last one was correct.
I'm not really sound, so we're just kind of
Exactly.
looking at sampling another question, and then where you have a question or where you're not confident in your response, you know that's when you need to go back and study. Is that okay?
Yes.
Alright. In most states, the possessor of land owes the greatest duty of care to which of the following?
Invitees.
No, it's an invitee. Okay. A person who falls asleep while driving would not be liable for any resulting injury since it would be an unavoidable accident. Interesting question. Alright. Which of the following statements are true as relates to libel and slander? They are both forms of defamation. Libel is spoken, slander is written. The burden of proof for such claims is clear, cogent, and convincing. Only 2 of the above statements are correct. Well, now let's pause on this one for a moment. So Rebecca arrived at Mockingbird Lanes, a bowling alley in Omaha, Nebraska, where it is probably the relevant. So she comes to a bowling alley, okay? And she arrives at about 6 p.m. to bowl in her league game. The bowling alley's parking lot and adjacent sidewalk were snow and ice covered. You can't be pictures of the window.
I can't remember it.
So I'm sorry, it's okay, I should have said the groundwork. So we're sort of reviewing, we're looking at the eyes and forth, but you should not have pictures of that. Now you gotta make me change the damn question.
Oh, I didn't get a picture.
Good, alright. Okay, so the bowling alley's parking lot and adjacent sidewalk are snow and ice covered. We okay with that idea? Okay. Alright, so she proceeded to walk into the bowling alley on the only sidewalk provided in and out of the building. She testified that she noticed the sidewalk was icy. Pause right there. What do you think?
She knew.
So-
She
so-
saw it.
I see.
She
That's
saw it.
That's right. So automatically you're thinking right now probably negligence for the bowling alley, right? So we have that kind of idea, maybe, right? But then we go right to her. We're thinking negligence with the idea of the snow and ice covered, all that kind of stuff, right? But then we get to her and we're thinking, oh, wait a minute though, but you saw that it was icy or whatever, right? And we're talking about bowling. We're not talking about get to the hospital, right?
Right.
Right? So we're the idea of what?
I don't know.
Contributory
Yes,
negligence.
ma'am. Contributory negligence. Okay, let's keep going. Is everybody okay with that?
Yep.
Okay. All right, so after bowling 3 games, drinking 3 beers, because you drink and you bowl, she left the bowling alley at approximately 9 p.m. She retraced her steps on the same sidewalk, which is still ice covered and in a condition that, according to Frank Jameson, general manager, was too unacceptable for the bowling alley to be open to customers.
Huh.
The general manager name?
Yeah, so now we go back to what? This idea of what? Negligence for the bowling alley people, right? But then it's still, but we still have to balance that over the idea of her contributory negligence.
And
Because
she's
now
been
we got
drinking.
now
Yeah,
she's compounded it by the drinking.
And it was open when she walked in and closed when she came out.
Yes, ma'am.
So it could have got worse.
It's all right. Okay, so let's see here. As she proceeded along the sidewalk to her car, she slipped, attempting to catch herself by reaching toward a car and fell. She suffered a fracture of both bones in her left ankle as well as a ruptured ligament. I was kind of creative.
You
All
were
right.
right.
So she sued this company who's doing business as Mockingbird Lanes, alleging that they were negligent in failing to keep the sidewalk in a reasonably safe condition, and failing to warn her of a dangerous condition, and in failing to take adequate and reasonable measures to protect her. So we just kind of broke that down as we went through.
Wow.
You okay with that? All right, your counsel present and argue 2 defenses that they should assert.
So we get to be,
So you're gonna defend the bowling alley people.
defend the bowling alley.
So what are 2 defenses that you would
She knew it was
assert?
icy when she went in, and then she drank.
Right.
She's still contributory negligence.
Mm-hmm.
There's no way to tell how much she had, how intoxicated she was when she left.
Okay, what's the other one? What's the other defense that we're gonna? What's the other one? Because she saw it, she appreciated it, and she said, okay.
She didn't say anything. She went
What
for
is
it,
it?
they could fix it.
But 4?
No. So go back and look at the defenses that we spoke about. So you guys are very good. You jumped. No, not that one. You jumped right on the contributory negligence, which is good. Contributory negligence, remember, says that this person sort of, they contributed themselves. The other one says that I saw the risk. Yes! Assumption of the risk. Remember? I saw the risk, I appreciated, and I proceeded. We okay with that? So those are 2 potential defenses, and we will go through and we talk and we do an analysis, weaving in the facts that help support that defense. Did I lose anyone? Okay. The necessary elements of actionable negligence are duty to exercise reasonable care, breach of duty, foreseeable damage proximately caused by breach of duty. That sound right?
Mm-hmm.
All right. Under the doctrine of respondent superior, employers are vicariously liable for negligent acts or omissions by their employees where such acts are committed in the course and scope of such employees' employment. That's pretty straightforward. Okay, so I don't want to trick you. And so if you're just noting down like true, false with the message with the whatever, I'm gonna tell you it's gonna be switched. So don't set yourself up for failure when you go through and you do the quiz, okay? And you sort of jotted down the answers because I'm switching the order of the questions, okay? Does that make sense? So I'll make sure you're not tricked. All right. Oh, did we do that one? No, sorry. Okay. All right, under the doctrine of respondent, I thought we did. No, we did. Okay. Under the doctrine of respondent superior, an employer will be considered liable for the acts of an employee, even if the employee proximately causes harm while off on a frolicking detour away from the business of the employer. False. Yep. Standard of care is a degree of prudence and caution required of an individual who is under a duty of care. A photographer for Tacoma City News snapped a picture of Professor Jackson as he was sleeping under a tree in a newly dedicated public park. The Tacoma City News printed the picture along with others taken at the park with an article about its dedication. The following day when Professor Jackson returned to work, he was disciplined by his boss because he had informed his boss he had missed work due to being ill. All right, so Tacoma City News is guilty of false light? No? It was false?
The story wasn't about him though.
Guilty of invasion of privacy?
No.
He was in a public park.
Public park.
Guilty of disparagement?
No, he didn't know, the photographer didn't know what he was doing.
Unlikely they're guilty of any tour.
Yeah.
Which of the following is correct with respect to the reasonable person standard? It makes allowances for mental deficiency. It does not make allowances for physical disability. It applies an individualized test to children that takes into consideration the child's age, background, and experience. It imposes a higher standard for those with specialized knowledge and expertise. 2 of the above are correct. If a statute is found to be applicable to a certain situation, then the courts will hold that an unexcused violation of that statute, which causes injury to another, is res ipsa liquidator. What does that mean? What does res ipsa liquidator mean?
as it is or ourselves.
That's right. That's right, the thing speaks for itself, okay? Negligence per se, is that what it is? Strict liability? Assumption of the risk? Right, go back and revisit those. Each of the following statements is true with respect to the issues, analysis, and determinations made in the Barrett case. Okay, you just need to read the Barrett case, and I see a typo right there, so I'll fix that. Alright, so make sure you read the cases, alright? Any questions about that? Nope. Alright, if we go for about, if you give me half an hour to talk about case briefings, we'll be done at 8. Yes?
Do it.
Alright, let's do it. Alright. Yes.
So when we go through the case briefing and we see things after we've talked about it, can we go back through?
That's exactly what we're doing. Okay, so here's the idea. Some people have not submitted the case briefing assignment, that's okay. What we're gonna, so I'm gonna give you some general feedback based upon the ones that I have seen that have been submitted, all right? Then, if you go back and you look at yours and you see some, that you can benefit from some of the feedback here that we've discussed, then you can go through and change yours, all right? And what I'm gonna do is ask you if you can please get them in by Tuesday. What's today's date?
Monday.
No, Wednesday. Is that all right?
This Wednesday.
Wednesday by
Yeah,
midnight?
Wednesday. Wednesday by midnight, yeah, that's good. Okay, all right. See here. Let me do it this way. Let's do it this way. Raise your hand if you'd be comfortable using your case briefing as a model for the class. You okay? Are you coming back? Okay. So we'll wait till you get back then. Okay.
I don't know, but I'm scared to just rip it apart.
Mine knows what not to do, it's too long.
So here's the thing, it's a learning exercise.
Okay.
These are gonna take practice, all right? And so to the extent you feel comfortable sharing, we're all gonna benefit from it, okay? But if you don't feel comfortable, then please don't volunteer, 'cause I don't want you to complain about it. Yes, anybody? Courtney? Okay.
You can use mine too if you want to use more than one.
Let's see here. Well, let's see, because we'll look at your, I'll put it on there, just one moment, let me figure. All right, here we go. You see? Excuse me, sorry. See, there's, so up here on the panel, there's supposedly what's called a mute button, and you just press that button, and it's just black out the screen. But this low budget antiquated thing doesn't quite work like that. So I have to.
Overall, how did you do as a class?
Did you look at them?
Yeah. So overall, I think that
She does not.
She's
like, who do I say? Answer. Oh, man. Oh.
No. I think that. Well, here's the thing. Because I only have half of them, I can only project by half of the class. But for the most part, what I saw, I think was pretty good. I think these are great for your first case briefing for many of you. And the other thing is great for a case briefing with me. If you haven't heard, I'm a tough cookie, right? right? So, I mean, there are certain things that are required that you might not necessarily be required to do in another class where you're doing these, okay? So just that you can't, that you're here in class tonight, having turned this in on Saturday, that's like, you know,
That's
okay?
kudos.
Seriously.
Well,
extra
you use
points.
mine, cause you ought to be able to redirect a lot of things.
Okay, so let me, gosh, I hope this comes up so we can do this. Hold on one second, I'm sorry.
It says that 30 minutes is up.
Huh?
The computer's telling you your 30 minutes is up.
Okay, let's see. Okay, guys, hold on. Let me try it one more time. It's a new signal. Okay, so went to the DocuCam. All right, now let's press PC. Finances sticking out. Okay, so now remember, even if you did not select this case to do your case briefing, you still have to read each of the cases, right? And you can see that because that's why I tie them in to the to your quizzes, exactly, okay? So you want to make sure, because the idea of the cases is that they're supposed to be further explaining or elucidating those big themes and concepts that are introduced in the chapter, okay? So it tells you, here's the boilerplate law, and then here's a case that applies this law, and you can see how it plays out, okay? All right, so material facts. On October 5th, the plaintiff's pilot delivered the aircraft for a 6-year inspection of the landing gear and undercarriage. Upon completion, the plane was returned to the pilot, and as instructed by the defendant, took off and tested the landing gear. So I know what you're saying by virtue of having read the case. Do you? Got changes? Uh-oh. What I say here is, uh-oh, did I click it? Why did I know that? Sorry.
Do you have the show markup? Is it on there?
Yeah, it should be on there. As soon as you click on this, it should be on there.
Yeah.
There we go. All right. So, you okay with that, Courtney? Because I read the case, I understand what this means, but otherwise this should be clear, okay? So indicator lights in the aircraft signaling a problem with the right landing gear. The pilot contacted MAC, was instructed to return to Monroe. The plane's landing gear was then inspected again and deemed working properly. After taking off a second time, the pilot once again tested the landing gear with the same result. The pilot returned once again to Monroe, and after landing, the right gear collapsed and was up. What do you think about material facts? Anybody?
Well, I read this too, and there was another person in the airplane with him the second time.
No, it was Mac Mechanic that went with him the second time.
Nichols.
Okay, what's the purpose of a material facts?
Just to state the
Irrelevant
reason.
Huh?
Irrelevant
Relevant facts? I give what? Backdrop to how legal issue arises, okay? So I go back and look at this and try to see if we can truncate this more and just get some clarity. So the bottom line here is all we're talking about. So everybody remembers this case, right? All we're talking about is a company takes their plane in for the required inspection, right? Upon picking the plane up, the landing gear is not operating properly, okay? After twice returning and being informed that the landing gear is operating properly, they take it back and ultimately the plane crashes, period. That's it.
Short and sweet?
Short and sweet. You just need the material salient facts so we understand the issue. Are you guys okay with that? Do you understand what happened with the case?
Yes.
That's it.
So I did the one at the Wells Fargo.
Okay, so let's get through this one first, and then we'll come back to the Wells
Okay.
Fargo.
All right.
Are we okay with this idea for this one? All right. So procedural history. Plaintiff filed a petition for damages and then moved for summary judgment. The court rendered partial judgment on the issue of liability in favor of the plaintiff. Is that what is there anything else? What was the basis of summary judgment?
It was in favor of.
That's right. So we want to kind of understand, okay, well, what was the basis? So what determination was made? So yes, we got that summary was granted summary judgment, but based upon what? What was their claim? What was the plaintiff's claim of action? This is very good. Don't confuse claim with their theory. That make sense?
Yeah.
Their claim is negligence. Their theory of how they prove that negligence, they look at the race as a sequitur. You with me? That make sense? So plaintiff filed a petition. Plaintiff filed cause of action for negligence based upon theory of race. Okay? Plaintiffs, and then you can do your motion for summary judgment. Plaintiffs. Motion for summary judgment. We want to really be clear. Plaintiffs. Subsequent motion for summary judgment was granted. You with me? And then the defendants appealed. Is that right? Because I'm not looking at the case I think here. Issues presented. The defendant argued, so what are we going to say about the issues presented before I even read any further? Yeah. Phrase in form of question. You okay, Courtney? Mm-hmm. All right. Yeah. And thank you for sharing this, okay? Alright. The defendant argues the court should not have granted partial summary judgment because no depositions have been taken. Okay, this is very good. Because this is part of the issue. This is part of what they argue, right? This is secondary, right? But it's part of what they argue. And we can spin what you have here into a question and we'll be on point. Okay? Did the trial court err in granting partial summary judgment where no depositions had been taken? Make sense? Or discovery had not yet been completed? Yes, sir, and yes, ma'am.
Should the question be in the form of a yes or no question?
Should be in the form of a yes or no question?
Yes or no answer question?
Yeah, you want it to be simple, okay? So and remember, we're always kind of starting with the idea of did the trial court, remember, if they're on appeal, they're looking at something below was incorrect, okay? And I think it'll be easier for you if you try to form a yes or no question. It might not always work that way. I can't tell you that everything is a yes or no question. But I think it'll help you if you can do that. Yes, ma'am.
I wrote, was the actuator damaged prior to Mac's inspection of the landing gear?
Was the what?
Was the actuator?
Was the actuator damaged prior to Mac's inspection of the landing gear?
Was the actuator?
Yes, that was the actual thing that ended up.
Was the
being broke.
actuator damaged?
That's what caused
prior
it
to-
not to work.
See,
What's,
Is that too general?
I think that's a little bit more specific than you need to
But
be.
that's the question that they raise in the appeal.
But the question that they raised in appeal
Was
was
modifying the res ipsa of.
exactly. Okay? So you're getting down into real.
that was more like
nitty-
a claim, right? They were just claiming.
So that you're
that
getting
might
down
be
into the
official.
real nitty gritty. So when you go back and look at the look at the text, look at the text. Is the court nice to us?
No.
In this case. Well, I told you they weren't always going to be nice. John, can I use your book?
241. Page 241.
Okay. I didn't bring my book, so. Okay. All right, so let's see here. Skip down to. When you look at, sorry. Here we go. So page 242, I'm looking at the second column, right? And see how it says, so based upon the record, the defendants failed to present evidence to demonstrate the actuator was scratched before the inspection, blah, 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 whatever, right? But that's what they're looking at in terms of determining whether or not it was appropriate for the court to grant summary judgment based upon the res ipsa liquidator. And that's why the court says in the following sentence, consequently, we cannot say that the district court erred in concluding that the defendants failed to produce factual support sufficient to overcome the inference of negligence that was most probable cause of the accident. The inference of negligence, that's the theory of the res ipsa liquidator. Remember, res ipsa liquidator is the idea that it speaks for itself. We have to infer negligence because that's the only possible way that this could have happened.
So with that
So you can even spin that into your issue.
with that question, we just need to ask, did the lower court err
That's
in
right.
making their
So
judgment?
So we were just looking at the first one. When we look at the second one now, did the trial court err in applying? Yes, exactly. We could just spin that, or we could just
Spin
make
it
it into
into
a
a
formidable question.
Okay.
So you got the nuts and bolts here. Okay, we're just tweaking it a little bit, using the monkey wrench to tighten it up. Is that a tool? That is a tool.
Yes, it is.
Okay, thank you. All right. Points of view. So are we okay with this?
Mhm.
All right, points of view. The plaintiff understandably feels the defendant was negligent due to the fact that there had not been a problem with the landing gear prior to the defendant working on it. Okay? The defendant argues that the defective actuator was the cause of the landing gear malfunction and not negligence on their part. I'm not clear how that helps them. I'm not clear how that alone helps them. You with me? So we want to flesh that out a little bit more. From a moral point of view, it can be argued that the defendant should have noticed the defective actuator before the initial inspection. And again, during the second inspection of the landing gear, after the pilot's first test flight revealed the malfunction. The defendant was tasked with making sure the landing gear and onboards were in order, and they failed to do so. Okay. Where was that?
So you want two?
Nope,
One more.
you gotta have to have, how many?
Four.
Four, so this is some of the feedback, they gotta have a total of 4.
Oh.
You have to have the plaintiff's perspective, you have to have the defendant's perspective, and then you have to have 2 additional. Okay?
I misunderstood that. I thought you said other than the defendant and the
That's
plaintiff.
exactly why we're doing the exercise, okay, because you have to have a total of 4, okay? Alright, let's see here. Rubric. Point of view, blah, blah, blah. In addition to the parties, so in addition to the plaintiff defendant, at least 2 other points of view. Okay? Alright. Let's go back. Rule statement, according to blah, 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 either party may move for summary judgment anytime after the answer has been filed. There is also no absolute right to delay action on a motion for summary judgment until discovery is completed. Very good. This is part of the course, right? Race ipsa loquitur rule of circumstantial evidence where negligence is implied because the facts indicated in defendant's actions are most likely the cause of injury. Are the most likely cause of injury. Okay? So
This really confused me. Could you explain what the rule statement is?
So the rule statement is, how do we find that case? So it's gonna be it should be in the case itself, and all the rule is, right? This is a court saying, here's the authority that applies in this case. Here's what we're gonna rely upon. Here's what the parties have to show. So hopefully, we're not just getting the court just sort of going off a whim or emotion or something. They're gonna cite to some sort of statute, as they do here, or they'll cite to some sort of case, as they also do here. And that case and those statutes, or whatever, are gonna basically articulate some legal principles that are gonna help guide its decision. So in this case, what it says is, okay, these parties are arguing about whether or not summary judgment was appropriate at this point in time. Right? That was one of the issues. They were saying, well, wait a minute. Summary judgment is premature because we haven't finished the discovery process yet. We haven't finished collecting and gathering evidence and so forth, right? So the court says, well, there's a rule that applies to this, and that rule says that either party may move for summary judgment any time after the answer has been filed. There's also another rule. That other rule says there's no absolute right to delay action in a summary judgment motion until discovery is complete. You follow the thing? So these are two of the rules that the court's going to look at. Now they're going to apply it in this case. They're going to say, okay, well, ask the first issue as to whether or not summary judgment was premature. Looking at the rule is clear that there's no requirement that discovery be complete. And in this case, had some discovery been done?
No, they didn't do anything on their part.
Who didn't do anything on their part?
The defense didn't give
They
anything
didn't do
for a year
anything, but the
anymore.
other party had, right?
Mhm. And they didn't.
Right, and so the court talks about that. The court says, hey, the defense elected not to do any discovery. That's sad, but it's too bad because the rule, right? And then they go on to say that because of the answer had been filed, it was more than appropriate. So as to the first issue, the court says summary judgment was not premature. Okay? Then on the second issue, looking at whether or not the res ipsa loquitur was appropriately applied, then we go into that analysis. They give us a rule for that. So res ipsa loquitur is a rule of circumstantial evidence. So again, they give us the rule, period. Now you're not doing any analysis at this point. You're just telling us what are the rules that the court's gonna apply.
And so for the res ipsa loquitur, that's sufficient, or do you have to put in all this, the 1, the 2, and the 3 that the court was looking at?
That would be more complete in terms of what the elements of that are. So here's the general explanation, right, of what that doctrine means. And then we go back and we look at, it's on page
241, it's first column, third paragraph.
The test in applying res ipsa loquitur is whether the facts of the controversy suggest negligence on the defendant rather than some other factor, or blah, blah, right? So the court indicates that the test is blah, 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 and we articulate that. Is that okay? Application. Use transitions and use introductory language to help make your analysis clear, okay? And what I mean by that is the court first looks to this issue. The first court looks to whether or not the summary judgment motion was premature. You see how you told me exactly where you're going in the first issue that you're gonna discuss with me, right? You just pretend like you're taking someone, you're guiding them. Well, first the court, they do this, they talk about this, and here's what they say about that. The next issue the court addresses is whether or not there was sufficient evidence to raise it, and then give you the analysis there. So transitions and introductory phrases, okay? So let's look at the analysis. In this case, the defendant's answer had been filed in September 2007, approximately 1 year and 8 months passed before, hold on. In this case, the defendant's answer had been filed in September 2007, approximately 1 year and 8 months passed before the plaintiff filed a motion. No. This is a very good fact that you're pulling out to help us understand how the court analyzes. So remember the court said that, hey, as long as the answer's been filed, you can make your motion for summary judgment, right? So what I'm getting from this is that the motion for summary judgment was made 1 year and 8 months after the answer was filed. I want you to say that and be direct, be more direct and explicit with it. You with me? So we're sort of chop this up together. The court first considers whether the trial court was premature in determining the motion for summary judgment. Oops. Right? The court having noted that a party can move for a summary judgment anytime after answer is filed, right? Answer, please stand tight, file. Huh? What are you laughing at? You try typing like this, all hunched over and all.
Just
Look at mine.
Alright, so the court.
Yeah.
Okay,
trying to figure out how.
so this is getting worse. Period. In this case, the answer, the motion for SJ was filed when?
1 year and 8 months.
Approximately 1 year, 8 months after, right? After the answer? Period. So you see how we took so what we've just done is summarize the court's application of that rule to the facts. Okay? We're done with that. That's all we need to say, right? Other than some stuff about the court notes, so they have plenty of time to do discovery if they want to do discovery. Listen, assuming that was the case, right? Assuming that we didn't have this rule, they still had plenty of time to conduct discovery, and that's basically what the court says. Okay? So you might have a sentence in there that says the court knows that they had plenty, if they wanted to have done discovery, they had plenty of time to do so. All right. Oh, good. In that time, no attempt to say, oh, but this is good. Good. Well, so we keep that. There also had not been any request for very good. That's exactly what we want to have there. Does it make sense? Flushing out the court's analysis. Okay? All right. Then our transition.
The court now considers the application of res ipsa loquitur.
The application of the, and then blah, blah, blah. What does the court say about it? Didn't the court apply the factors?
Yes.
Applying the factors and set forth in the, where did they get that from? They got it from a case, right? What was the case that they got the elements from? Oh, John, I'm sorry, you have your book back. I'll give it to you. What's the case?
Eason versus Finch.
Eason? So we say Eason?
Eason, yeah.
Whatever. Find the factors set forth in Eason. The court finds that blah, 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 blah. The court notes that the effective factor, blah, blah, blah. Okay with that? Is this helping or are you guys?
Yeah.
Okay, all right. Conclusion holding. What are we gonna do with the conclusion holding? Go right back up to our issues and spin that into and spin that into a statement. And just answer the question.
Say it again.
So go right back up to the issues. Remember that's the benefit and the value of phrasing as a yes or no. Because now we can just come back, copy and paste that joker, put it right down there and say, no, the trial court did not err. Yes, the trial court erred. Okay? Alright. Judgment? Would affirm the original verdict?
So in your example, you had two pieces of the conclusion holding. There was sort of a general holding and then there was a fact specific holding.
Good question. And what that relates to is sometimes a court is gonna sometimes the court is going to reaffirm a legal principle. You with me? And so it's not necessarily contingent upon the facts of that particular case. So let's say, for example, in here, maybe the court was clarifying like one of the elements of res liquis impetor. So, and we would say the court clarifies that something is an element of res liquis impetor. Period. That's a general holding. Period. With me? But then the fact-specific holding relates to how the court's holding applied to the particular facts. In this instance, the court finds that in applying this element to the facts of here, the fact that the actuator, whatever, was not previously broken, is a basis for, res liquis whatever. Let me give you another example. Let's say, Remember when we did the example with the alcoholic beverage stuff? Mm-hmm. With me? Let's say the court was going to reaffirm, okay, alcoholic beverages are deemed to be beverages that are explicitly promoted as whatever, liquor, and have 2%, I don't know, is that how much, 2% alcohol? I don't know, we're making it up. Okay, so that's a general principle. But I think that's a general principle that came out of one of those cases, okay? The court, so in addition to this general holding that we get about how how we're defining alcohol, then the court applies that to reach a fact-specific holding. In the present case, Vicks cough syrup is not an alcoholic beverage, period. Does that make sense? So this general holding, we can lift this up and we can put it into another case, and it's not going to be contingent upon these facts. This fact-specific holding, we're actually tying in it to those facts in that particular case. All right? And you'll see some more examples. Yes?
I noticed on one of them, it actually said that at the bottom, and I don't remember which one it was, but it said that the statement didn't take away from what the previous law was. You have to add that in there, or?
No. So here's the thing. Sometimes the cases are going to be really clear. There's a general holding and a fact-specific holding. They're going to be really clear about that. So that's why I gave you the example of those. Okay? But otherwise, just shoot for here, and you'll be okay. Shoot, at this point, if you get any one of these, I'm going to give you something. All right. Okay, and then let's see, last thing, judgment. So judgment's good. Case proves the company cannot be negligent.
I honestly, with that part, just let it go. The company can't be lazy and then go back.
No, so remember the significant comes so the legal principle. How does this case impact your understanding of the legal principle? How does this case sort of move that legal principle forward? Or maybe it makes a change that sort of takes it back a little bit. So what do you now understand more about? What was the legal principle in this case that they kind of explored? What was the big thing? The res ipsa liquitor. So I think that part of me, for me at a baseline level, I'm thinking I'd probably get a better understanding of when that doctrine is applied. Because the court makes it clear that it's applied when you're trying to infer negligence because you don't have any direct evidence. Because that's all this case was about. They didn't have anything to go on. They're saying, look, we don't know how it happened. All we know is we took our plane here, and when it came back, it didn't come back like this, it came back like this. So we don't have any direct evidence. And that's the idea of the res ipsa liquitor. Okay? Oh, here.
So significance here means for us, not for the
overall.
So I
I
didn't
would
know.
think
No,
that
it did-
for-
no, but
For
it-
a lawyer, looking at this, they haven't learned anything new. Or
No,
both.
no.
The
Yeah,
court
because
to affirm that-
here's how you know that the lawyer learned something new, because we had an appeal. You with me? That means somebody below got this wrong. So what any person can take away from this at a baseline level is the application of this res equus literature principle. So yes, it is you, but it's you thinking about the legal principle that's been explored in the case. You with me? Just like over here with our alcoholic thing, I would say the significance from that is understanding when the court applies or what is going to constitute an alcoholic beverage. Now we have a better understanding of that for application in future cases. Okay?
So
Hi,
then,
yes?
if you put the overall, the implication of the overall case, the ruling could have had on society, would that not be correct?
Because I don't want you to think about it in terms of society. I want you to think about it just in terms of the legal significance. Now, the legal significance could have implications for society. You with me? But I want you to think about it purely in terms of what's the significance of the legal issue that's been explored. What do we take away from this? How does this move us forward? What do you learn about this legal principle based upon what this court has now held in this case? And that could be different. It's going to be different for every case. Ma'am, what did you take away from the Wells Fargo's case? I don't remember your name, but you asked me about it.
I totally did that wrong. I didn't do it from the legal perspective. I took it as a society perspective, like what society would get from that case.
That's a hard case. That's the one where they go into the bank and he's kind of profiled in some sense,
I did that
right?
one too.
Basically,
And
like,
then it's YouTubed or whatever, right? And what YouTube, one of the things you get to take away is the idea in terms of proving negligence, right? That you actually have to show that there was some sort of duty or standard of care that was breached. And in this instance, that can be kind of complicated when you actually have these sort of circumstances where everybody's trying to do the right thing. They're trying to protect the bank. Right. So did they breach the duty of care because they kind of, went,
No, they
breached the duty
didn't.
of care because they profiled them? I mean, yeah, you know what I mean?
That's what I
It's
did.
more
I
complicated.
did like the society perspective, like, I mean, that was like a big issue that they didn't bring up about, was there-
So you can put that in the
Yes.
points of view. From a
Okay.
societal perspective, blah, 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 blah.
Right.
Okay.
Okay, so that's what that would go. How you feel? All right.
Did you make any notes on ours already, or?
No, I just went through and I just read them. So Courtney, you have the benefit of some notes, but I'm not gonna give it to you.
So
All right, so go back.
Short
Yes.
and sweet.
So how do we resubmit ours? Like if we've done, I've done it, so.
Yeah, you can just go back and submit it again.
Just submit it again.
Absolutely. And to be clear, at the very top or whatever, just say revised.
Okay.
Yeah. And that way I'll look at that one, you already submitted it. The other thing is, Courtney, thank you so much for keeping the format of this. Do exactly what you did here. Keep the headings, keep the bold captions, keep it single space. Please do that, okay? All right.
Short.
Huh?
You want it short.
Yes, agreed.
Mine is not short. Mine's 6 pages too. I think it's like 6 pages.
felt like more than
I do not want to read 30 times 6 pages. I'm sure it's lovely. All right, you guys drive safely and email me if you have any questions. And thank you so much.
Can I ask? Should I email you to make an appointment?
Yes.